speaking on behalf of the appellant. The first issue I'd like to bring up is that the car is not part of the residence. The car is on the driveway, and the driveway is part of the curtilage, which is the area that surrounds the residence. The actual residence is the structures that the person actually lives in, so it's a subcategory of a house. And they have a specific warrant for the residence, not for the entire house. And if you have a warrant, if you need a warrant for a vehicle, it has to be a specific one with a description, and in our case, that was not present. The second issue I'd like to bring up is that the laptop was not in plain view, because it was inside of the laptop case. There is no 100% way to make sure that the laptop is for sure inside of the case. That's a subjective statement.
Does the vehicle exception have anything to do with the search of the car and the warrant for the car?
No, because the car exception is that the vehicle be in on a public road, and the officer may stop them, and that's not the case. It's on the driveway. And the second one is that it discovers the vehicle in a non-residential area. And so this is in a residential area. And since probable cause is it has to be an objective concept, the officer's belief that the laptop would be inside of the case is subjective, and that does not constitute probable cause. So that cannot be used here. And it was an inadvertent discovery, so the plain view doctrine does not cure inadvertent discovery, because the officer was anticipating that the laptop would be inside the case. And Justice Stewart from Coolidge v. New Hampshire, he said that in order for the plain view doctrine to work, that it must be immediately apparent that the laptop is inside the case. There is no way that you can make sure that it is in the case. Even though it's anticipated, that does not work. Just as in the Arizona v. Hicks case, where the stereo was illegally moved to find the serial numbers on the back. It would be anticipated that serial numbers are on the back of the stereo, but even though they moved it, it was ruled that it was legal because you could not see the serial number from where they were positioned.
But in that case, he was investigating a gun shop and found a stereo. In this case, he was looking for a computer.
Yes, the warrant was for inside of the residence. The car was not in the residence. The residence are the physical structures in which the person lives. And in the Harris v. U.S. case, it was an arrest. So they were able to search the surrounding areas because it was an arrest, and because the guy had government papers in his possession, and the crime was having the government papers. So they were allowed. So the crime was being committed in front of the police, and that's why they had the right to search the surrounding areas, mainly because it was an arrest.
I'm arguing that it was, in fact, one count of possession, not two. In the People v. Herzig case, Herzig had 30 different images on a laptop of different subjects and different pictures, as opposed to one in our case, which was duplicated. And the Herzig court reasoned defendant violated his provision of the penal code by solitary act of possessing prescribed property, like just a solitary act of having it, not irrelevant to how many he had.
Does it matter that they were in two different places?
The intent was not to have it in two different places, as we had the automatic setting on the backer drive. And I would like to point out the definition of the word house as the residence. A house includes all of the four things: structures as residences, buildings attached to the residences, such as a garage, buildings not attached, as like a shed, and the curtilage, the land surrounding the home. Although they were found on the same, although they were not found on the same residence, they were found on the same house and property. So they were in the same place, and it's also important that the warrant was for the house, or for the residence, and not for the house. They were both in the same house, and within the same general time period, but we do not have a warrant for it. In the Von Rada case, the marijuana found in two different cities, it was found in two separate accounts. Now, that cannot be used against us because it was also in two different searches in two different cities in two different periods of time altogether. It was assumed by the quantity that it was intended to be sold, as well as possessing and consuming. Now, in our case, it was only the only intent was to consume. consume, or excuse me, to possess. And this is only one crime penalty intended to sell. In the Van case, the rule as to each offense, the specific conduct evidencing possession was different, the purpose was different, and the subject matter of the possession was different. Now in ours, the conduct with the possession, like if you're going to sell it or not, it wasn't different, it was just one intent. The purpose was different, it was the same purpose in our case, and the subject matter of the possession was different. It was exactly the same in our case on both the laptop and the hard drive.
Is a victim of child pornography only victimized once, even though it is possessed? I mean, yeah, like people consent.
Well, it was the same image. So it didn't happen to the child multiple times. It only happened once. And it does. And I also want to address, it doesn't matter if he was leaving the residency. It never said that the car was on the residency. The car could have been on the sidewalk. Could have been. I mean, I understand it was on the driveway, but it doesn't. It's not. It doesn't say specifically against that residence. The driveway is part of the residence.
But the curtilage is not part of the residence. The curtilage is part of the house.
I close with the following judicial response from People versus Rowland, a case which involved 3 different weapons found at the same time in the same house. You are not at liberty to fragment a single crime into more than one offense. This is relevant as it is almost the same scenario, multiple possessions of a crime, but in one place, and it was convicted of only one crime.
Counsel for respondent, you may proceed.
So the search of the car was legal because as when we stated before, they said that the car was not on the residence, it's not on the curtilage. But the definition of residence is where the person, owner of the home, resides. The definition of home is including the curtilage, which is the garage, the driveway, the lawn, everything that. So you said that wasn't part of residence, but then the other appellate stated that the car was on the curtilage. So that kind of contradicts yourself. So, and also, you stated that the warrant for the vehicle, there was no warrant, so you need a warrant to search the vehicle. But you don't need absolute certainty that the laptop's within it, this is probable cause, which we had from the hard drive being found inside the house earlier. So, you said that the warrant stated to look for the laptop or electronic device which had photographic images on it. So that's exactly what they're looking for. And when the officers saw the laptop case in the car, he knew that he was looking for a laptop because he had looked and he had found a hard drive set out, and the hard drive backed up at the rear, and they knocked on a desktop inside the house. So they knew that the officers knew that he had to look for a laptop. And when he saw a laptop case, a reasonable person would assume that there was a laptop in there. So that is specifically what he was looking for. In the Harris case, the Supreme Court deemed that the search of the entire house was legal, and they did not even have a search warrant in that case. They just had an arrest warrant. And they deemed that the search of the entire house, including the curtilage, the driveway, the garage, was legal because it had enough probable cause. And that's the same in our case, because they had enough probable cause from finding the hard drive in that house to look into the car.
There was no arrest made.
True, but in the Harris case, we had no search warrant at all. And in our case, we do have a search warrant. So there was sufficient probable cause to look into the car. And it was the officer's duty to seize the laptop because the suspect could have, after the officer had left and did not seize the laptop case, the suspect, John Smith, could have brought it into the vehicle, driven away, and transported and or possibly destroyed the laptop as evidence of the photographic images.
What about obtaining a search warrant after seizing the laptop?
That's not really relevant to the appellant's appeal in the case. We're talking about search of the car and seizure of a laptop, not search of the laptop. So in the Chadwick case, it's similar because the police seized a footlocker without a warrant, and that was deemed legal by the Supreme Court because it had no probable cause to seize the footlocker because the vehicle inspection was placed on the footlocker, but it was in a car, so the locker could have been transported and or possibly inside could have been destroyed by the suspect if the locker had not been seized.
The vehicle exception only works for non-residents.
Right. So the vehicle exception works on public property, and as a previous appellate stated, that they said that in their opinion, the car was not in a residence. So assuming that it's not in a residence, it would be on public property. That's what they said. So also basically it was specifically the police officer's duty to seize the laptop and make sure that the evidence could not be destroyed, anything like that. So that's what that was.
I think the appellate mentioned the Von Lotta case, and they said that the reason it was deemed as two separate accounts is because it was in two separate places, two separate time periods, two separate searches, and two separate intents. And I believe that all of those things that they mentioned apply to our case. It was two different separate places. It was the house and inside the vehicle. And I understand that we stated that the vehicle was within the curtilage, but the thing that makes the vehicle its own separate location is the fact that the vehicle has the ability to move away from the curtilage. It has, because that's why the vehicle exception rule is placed on it, because they have the ability to move away and transport this pornographic image anywhere he pleased. And the fact that it was in his vehicle at the time means that he had the intent to transport it. He wanted to transport it. He had two separate intents by saying one was on his hard drive. Oh, yeah.
There are no two intents. That was ruled out in trial court.
There was ruled out that there was intent to distribute, but there's many different other intents besides the intent to distribute.
I think the only other one that can be used is possession, and that's.
Well, he had the intent. He had two separate intents. He had the intent to save it. One was to save it. He put it on his hard drive, which everyone knows hard drives are used to save evidence, to make sure that you have it, to ensure that you keep that safe. One was he had to save it, and the other one was he had it on his computer to take with him to show, like, who knows what he could be doing on his computer. He could be taking it to show his friends or to do who knows what.
There was only one intent according to the trial court.
They
intent to possess, saving and using it for his own purposes, and intent for possession.
I believe that they only deemed it intent to distribute, but they ruled out.
Okay, can we move on?
Okay, yeah. Also, it was found in the car, which is in a separate search. It was after they had searched the entire house. They had finished the entire search of the house, and as upon exiting, they saw the laptop inside and began an additional search of the car. So it was two separate searches, and therefore should be two separate accounts.
It was on the same property.
Yes, it was on the same property, but that's where the vehicle exception falls in. The vehicle exception, I mean, it's put in place because the car has its ability to move and transport evidence, and the evidence could be destroyed. And had the evidence been destroyed, there still would have been an additional copy. So, let's say the hard drive was destroyed, there would still be it would still be on the computer, which would make it two separate accounts.
Okay, so also a quote from page 2 of the fact pattern says that the police were able to obtain a search warrant which allowed them to search John's residence for the computer, which the email came from, and any other evidence of child pornography located at the residence. So it specifically says that they have a search warrant to search the entire residence. And the residence includes the home and the curtilage, so everything together, including the driveway, the garage.
Where's that definition? Where's that definition that the residence includes both of those?
From information we received earlier, definition states that a definition of a house includes curtilage and residence.
That does not, definition of a residence that does not include curtilage.
Well, a residence can be where a family resides and does intimate activities, and they can also do the same intimate activities in the driveway in a car. So it basically is better. And also, a viewer of child pornography, it's not a light